Well, no, I don't mean like this. I told her what she was trying to say that. They just got out.
Are you trying to not see us?
No, don't sit that. Yeah. I'm making things a little bit early for my train. Oh, sure. 30.
All right, hello. I'm going to ask folks to take their seats. We'd like to get started. I know people are still coming, but I want to introduce Ms. Orloff, and by the time she gets up and speaks rather than me, hopefully there'll be more people here, and she's the important one, not me. So today's training we're very excited about, protection for immigrant children, families. You're going to hear a ton of information from Ms. Orloff, and she'll give you references. There's handouts in the back, but references to websites and all that good stuff when she gets up. What I want to tell you two things before I introduce her. Number one, we're not going to take a break because we find it's easier if we just let people break when they need to break, rather than have the whole room go out at the same time. So just feel free if you need to take a break to get up and take your break and hopefully come back to us. So that's one. Number two, we have sign-in sheets in the back, and we are asking all of you to make sure you sign it clearly so we know who you are. And on this sign-in sheet, we're going to give this information unless there's an objection by someone to Ms. Orloff, so that her organization, NUAP, will have the ability to contact you. If anybody does not want to be contacted, I would think you would put your phone number down, but I'm just giving you the opportunity to let me know if you don't want your name turned over to her organization. They're not going to solicit you for anything. They're just there to give you information. All right, so Leslie Orloff is an adjunct professor at American University's Washington College of Law. She's the director of the National Immigrant Women's Advocacy Project, which is also known as NUAP. Is that the right pronunciation?
Correct.
All right. NUAP advocates for laws, policies, and practices that enhance legal options for immigrant women and immigrant victims of domestic violence, sexual assault, and human trafficking. Ms. Orloff's 34-year career includes working collaboratively with experts across the country to develop and implement immigrant relief, public benefits access, and family law protections for immigrant women, children, and survivors. Excuse me. She was involved in drafting part of the Violence Against Women Acts of 1994, 2000, 2005, and 2013, as well as the Trafficking Victims Protection Acts of 2000 and 2008. Ms. Orloff was a co-founder and co-chair of the National Network to End Violence Against Immigrant Women, and she has edited story collections bringing immigrant women's voices to national policymakers. Ms. Orloff has published numerous law and social science journal articles and training materials for attorneys, law enforcement, judges, and other professionals, focusing on legal rights and services for immigrant survivors of domestic violence, sexual assault, and other crimes. Ms. Orloff has received national recognition on many fronts for her work on behalf of immigrant women, including but not limited to fellowships at Northeastern University Law School and Harvard Law School, as well as the Kellogg National Leadership Fellowship. So without further ado, I'm going to turn it over to Ms. Orloff. Thank you for coming.
Thank you. Thank you for having me. Can you hear me in the back there? Yeah. Okay, good. Well, welcome. I'm very happy to be here. For me, this is particularly, I travel around the country, do a lot of training, and to come back to DC Superior Court is very important for me because this is where I started my domestic violence work. I was a law clerk for Judge Gladys Kessler in 1982 here, and then went from there to realizing that I was the first Spanish-speaking person in DC who knew what a protection order was, and ultimately started the domestic violence program at IUTA back in the 80s. Where I worked for 17 years. That's a little bit about me. What I wanted to do in terms of the sign-in sheets, the way we use them following this is I'll send you an email with a link to the PowerPoint today and all of the materials. So if you want the live links from the handout of the materials I told you, they'll be live there. It'll be in a web library of materials around that contain information about immigrant crime victims' legal rights. So family law, public benefits, immigration, protections from confidentiality, protections from deportation. There's a variety of different things there. There's a whole judicial training manual there, and there's a training manual for police and prosecutors as well, and adult protective services. So there's a lot of different things available in the library. The materials today are also at a Go link, which is up here. It's newapp.org/go DCSC 2017, so you can get to the materials that way as well. So learning objectives for today. By the end of the session, the goal will be for you to be better able to know accurate information about immigration law and how having that information affects just and fair outcomes in state court cases. Recognize the facts that indicate that a party qualifies for legal status or protection from deportation as a crime victim or as a child, depending on the case. Understand the role that Congress envisioned for courts in terms of U visa certification, special immigrant juvenile status orders, and be able to make, kind of, as a state court judge, either make or seek as a lawyer appropriate findings in cases that are helpful to the cases of to immigration cases of immigrant crime victims. And so I got involved in this work. I've had a special, believe it or not, I got funding from the State Justice Institute to do work to SJI to do work on SIJS, Special Immigrant Juvenile Status, and I get the numbers and letters mixed up all the time. But I've been doing work with a team of judges nationally, training judges, court staff, and lawyers and advocates who appear before courts on this range of issues. But wanted to I like to get a sense of kind of who's in the room, and so if somebody could maybe help me with a mic. Who's in the room and what you want to be sure to know when you leave the room today. And I'm going to ask the people to use microphones because I've got some hearing loss and I'd like to hear what you're saying.
Don't be shy. No one? Miss Singh, you don't have goals for today? I know you do, Miss Singh.
Yeah, you can pick on me, Judge Ross.
There you go.
Just to have an understanding of any immigration matters that would affect children who are in the involved in the child welfare system.
Okay, thank you, Miss Singh, for starting it off. Anybody from OAG? I'm coming to you.
I guess just because we don't deal with immigration obviously directly, but the U visa issue is significant for us. We deal with a lot of victims who are concerned with deportation, don't want to come forward. So we deal with adults and juveniles, so that would be a goal.
Okay. And I'm going to give you up-to-date information, literally what was on Department of Homeland Security's intranet last week, or early in this week.
Thank you.
Hello, I'm Stephanie from Legal Aid, here with all my legal aid attorneys, and Brett. And we would like to know, also similar to OAG, how U visas affect civil protection order cases and domestic violence, but also in terms of custody and child support. And maybe also if you can touch on public benefits a little bit, like should immigrants be searching or applying for these with all their information on applications?
Okay, great. Is there one here? Up here? Here it comes.
Get my Fitbit steps in.
We'll keep you moving. I'm Maggie Schmidt from the Network for Victim Recovery, and we're just looking to get a better understanding of immigration status intersecting with CPO and criminal cases to ensure that nothing that's being brought out in a criminal case can hurt them in an immigration case.
Okay. Great. Okay, that gives me, all of those things were, fortunately, things I was more or less anticipating, so that's good. So, just to start, what countries are you seeing people come from that you're serving in DC? Countries of origin. El Salvador. Ethiopia. Guatemala.
Ethiopia.
Ethiopia. Where else?
Latin America.
Pardon?
Many countries in Latin America.
Throughout Latin America. You're still seeing South Americans, I'm assuming. Yeah. Anywhere else? Ghana. Okay. Anybody seen Canadians or Europeans? Yeah. Pardon? Yeah. Okay, but they can be actually. You could have a student who's Canadian or British or Australian who's a victim of sexual assault at one of the college campuses here, and end up with a U visa potentially. So so the demographic data, when you look at the District of Columbia, 14.1% of DC's population as of the 2015 census, or census data, are foreign-born. Of that, a significant proportion, 43.8%, are naturalized citizens. 28.4% are undocumented, and 27.8% are either legal permanent residents or temporary residents. So when I'm talking about immigration status here today, there'll be a lot of people that you're working with that may be lawfully in the United States on a student visa, work visa, diplomatic visa, there may be many. But if they become a crime victim, many of those visas don't lead to lawful permanent residency or citizenship. And so when I often talk about this, I want to kind of upfront make sure that people are aware that we're talking about anybody. When we're talking about immigrant crime victims and immigrant kids who may benefit from the forms of immigration that we've designed to help survivors and victims, we're talking about anybody who's a non-citizen and not a lawful permanent resident. So it's a broad swath that includes both the undocumented victims, but also people that might have various forms of legal status that are not permanent. The other thing that's really important, particularly because I'm going to be focusing heavily today on family court issues as well, is that 24.4% of children under the age of 18 in the District of Columbia have one or more immigrant parents. Just to do a little experiment, raise your hand if you're either foreign-born or have one or more immigrant parents in this room. Just hold your hands up for a second. Look around. We don't all look the same, do we? I mean, there's a lot of diversity, and I say that going back to this issue about who's an immigrant and who might benefit from these. So that writ large, it's important not to make assumptions because you might be working with someone who's actually born abroad who speaks English just like me. And there may be issues present there. One of the judges I train with nationally has started a practice of just trying to make sure she's aware of looking at birth certificates of every kid who comes before her. Because the birth certificate will tell you a lot about, obviously, where they're born and whether they're foreign-born. And that somebody who may look like you or me or speak English like you or me actually might need this form of relief and is not being told about it because they're not speaking Spanish or Eritrean or whatever. The other thing that's important to note is there's pretty significant diversity in DC in terms of immigrant populations, with 23% Asian, 14% African, about 2.7% Canadian, 2.4% from the Middle East, Latinos being obviously the biggest, but 18% are European. So there is really wide diversity. And then the other piece of this is, I was just telling the judge earlier, I practiced in this court in the 80s when there was no interpreter services. And so, those interpreter services, not only in the courts, but everywhere throughout the system are super, super important because you've got a population where 28.6% of the foreign-born population in the District of Columbia, according to census data, is limited English proficient. So that there's really great need throughout the system on that. So I'm going to start off just giving you some background on some of the dynamics of domestic violence, in particular experienced by immigrant survivors. And I'm going to start with a video that was developed and produced by the Blue Campaign at the Department of Homeland Security to train immigration officials within DHS on their own requirements about protection of immigrant victims. And the way I like to talk about this is, is under immigration laws, even today, you've got groups of people who are responsible for removal of people from the United States or deportation. You have people at DHS who are responsible for giving legal visas. And you have people who are responsible under the federal laws of DHS for protecting crime victims. And just like no judge in this room gets to choose which DC laws they feel like enforcing on any particular day, similarly, those laws apply. And as far as, I mean, there's nothing that's changed in the VAWA T and U visa programs under this administration or since it was created. I mean, they've continued to develop and improve throughout the Bush administration, the Obama administration, the Clinton administration, etc. So what I want to do is we're going to start off with a training video from DHS. So you'll get, I did this when the guy was standing over my shoulder. Michael, good to see you. How are you? How's Julie?
Oh, Julie's fine. You know Julie. Look, Gloria, I got your mail again, so.
I am so sorry this keeps happening to you.
Oh, no, it's not a problem. Seriously, I get to come by and see you, so.
Thank you.
Absolutely. Well, there you go. We'll see you later then.
Okay, Michael, see you. And say hello to Julie for me.
I will. Thank you. Bye-bye.
Okay.
Having fun with your friend?
You frightened me. Michael brought me the mail.
Well, is he the only one? Are you sleeping with every man in the neighborhood?
I don't understand. I didn't do anything wrong.
No, you don't. I don't even know if that baby's mine. You know, I could have you deported in 2 seconds and take that baby from you. You speak to no one. Remember what happened the last time you upset me.
Sorry.
You imagine me sorry. This is my house, and I make the rules. And now I'm not going to file those papers for you. You see this?
No.
This makes you mine. You want me going nowhere? Now working without this.
No, stop.
Happy now? This is all your fault. Why do you make me do this?
So that is an illustration of immigration-related abuse, power, and control. And just as, and for in immigrant families, there are many kinds of instances in which a spouse usually will have power and control over the immigration status of their foreign-born spouse or child. It can happen in employment situations. We see it a lot in this city, where you've got like diplomats who have nannies working for them and people where they have a visa directly tied to a particular employer. What we've seen is those kinds of power and control, and the reason they're training DHS on this is if you think about it this way, back in the old days when I was practicing at IUTA, in all of my cases I would hear, they would say to me, you know, I'm afraid to come forward, he's going to get me deported, et cetera, but we never saw anything happen. Somebody at DHS explained this to me many years ago, but you know, as the federal government began to pour more resources into immigration enforcement, the way they explained it is in the old days, it was like there was a telephone, but nobody was sitting by the phone. They called and nobody was there. They didn't get an answer. Now, you have all this staff. So now they call, when the perpetrator picks up the phone to call DHS, there's actually somebody there who answers the phone who says there's an undocumented person standing at the corner of X or working at McDonald's or doing Y. And they act on that. They don't know, necessarily, that it's a perpetrator calling. And so part of the training is to get them to see some of the dynamics so they can identify when the perpetrator is trying to use them to avoid criminal prosecution, to win a custody case, to make the victim disappear when she wants to get a protection order, those kinds of things. And I'll talk more about the extent a little bit in a few slides, the extent to which that kind of power and control is occurring. But it includes refusing to file papers, threatening to turn her in, forcing survivors to work with false papers. So sometimes he'll go out and procure the papers that are false, make her work with it. Sometimes she'll have legitimate papers he'll destroy. So, I mean, it works in all kinds of ways. And as judges, one of the things you might see in protection order proceedings, for example, I know this happened in some of my cases, is that particularly when you're with families coming from Latin American countries or other countries that are civil law countries, what will happen is in those countries, a particular piece of paper, like you saw him tearing up the passport, tearing up the visa and the passport, making the identity documents disappear or destroy them is a hugely big deal in their home country. You can't walk around without them. It may not be such a big deal here, but she doesn't know that. What she knows about here is often what he's told her. So you'll find them asking for papers and asking to prevent the destruction of papers or asking to pay to get papers reissued. And some of it is because of the power and control, some of it, sometimes like if he's destroying passports or visas, she may need copies of those to apply for immigration relief that she qualifies for as a crime victim. So what happens is, and this data is actually the data we brought to Congress to get the immigration protections in the Violence Against Women Act. Violence self-petitioning was partially based on this data. And what we found is when we looked at all relationships in which a U.S. citizen or lawful permanent spouse could file papers for his wife, when there was domestic violence in the relationship, almost 3/4 of the time he never filed. And when he did file, he waited a mean amount of time of 4 years. In a normal relationship, if I marry a non-citizen, as soon as I'm married, I can file papers for them. It's immediate. There's a delay in processing, but usually when there's a delay in waiting to file, there's often this power and control dynamic going on. And the way I like to think about it is, I'm old enough to say, for some of the young folks, you might remember these two when you were really young. But when we did domestic violence training in the past, we would say, what did a cut telephone cord mean? You wouldn't randomly have a cut telephone cord, right? You did it because you wanted to cut off her ability to call for help. Immigration-related power and control is like that. It doesn't randomly exist in every relationship. It coexists with physical and sexual abuse. And it exists in about 65% of immigrant survivors who are victims of domestic violence and sexual assault within families report immigration-related power and control like you saw. And that the other thing we know is that the abuse rates, at one point we needed to look at, we wanted to understand if there was a difference between citizens and lawful permanent residents. It was actually a federal district court case going on the International Marriage Broker Regulation Act, and the marriage broker agencies were arguing that we put citizens and lawful permanent residents together in the data to hide the fact that the abusers were really the lawful permanent residents. Turned out it was the opposite. It turns out that when a U.S. citizen is married to a foreign-born spouse, likelihood of domestic violence rises to almost 60%, about 3 times the national average. And it's not that every relationship is going to be like that, but that there was a subset of U.S. citizens who are choosing foreign-born spouses because they're looking for a particular amount of kind of power and control, or they're looking for somebody who's going to be subservient, or whatever images they have. The other thing that's important to understand is that the sexual assault rates for foreign-born girls are also quite high. So I know, Judge, we were talking about trafficking cases. I mean, there's both the human trafficking side of the sexual assault, but there's also, when you break up and reconstitute families in the process of immigration, or you bring a 13 or 14-year-old girl from El Salvador to join her mother and her stepfather and his 6 brothers in a house. It sets up situations where sexual assault can be prevalent, and there was a big survey done in Boston in 2006 that looked at all high school girls in sexual assault, and they found that the sexual assault rates by high school were more than twice as high for U.S. foreign-born girls than U.S. citizen girls, and there were also often multiple incidents of sexual assault. The other thing you have is perpetrators of sexual assault targeting young foreign-born women. You know, if, and again, this is DC, so I mean, when I'm standing in the middle of Kansas, I give you the next example, it makes sense, right? But farm worker communities, right? If you're a sexual assault perpetrator and you know that the workers in a particular place are going to be undocumented women workers out in the field someplace, that's a great job, right? They're undocumented, they won't, you know, you can actually take that job and you're set up to be able to perpetrate your sexual assault without anybody complaining often. And so there are people that choose, there are perpetrators that will choose certain professions or to position themselves in a place where they'll be able to, where they're around vulnerable victims. The other thing that's important is the kinds of immigration-related abuse that I was telling you about. This is the data. We believe that immigration-related abuse is a lethality factor. When you think about lethality factors in domestic violence and child abuse, domestic violence cases, what we've seen from the data is that this kind of immigration-related abuse that you saw in the video coexists with physical and sexual abuse. So, if you're a victim advocate or a lawyer and you're working with a case and you've got a lot of information, or you're a judge and you're hearing a case with a lot of data, information on this power and control, threats to deport her, control papers, one of two things is happening. Either that information corroborates the evidence about physical and sexual assault, but if you're a victim advocate and they're not telling you that there's physical or sexual assault, one of two things is happening. Either they haven't told you about it yet, and it's really there, or it's escalating. Or you're looking at a case where there's a likelihood that there'll be escalation. So it's just important to know that. And then what happens is that we've done some research, and I'll show you some of this data later when I did a big NIJ national survey on, National Institute of Justice survey on protection order use by immigrant victims, cross-culturally, cross-language, with nationals all over the country. We collected the data. And that's where this data comes from. Or actually, no, this is from a different place. But in the protection order part, what we found was that advocates and attorneys play a huge role. Many people, that victims will use protection orders, and because of safety planning, lethality screening, what we were seeing is that immigrant survivors, where the cases were most dangerous, were actually going to get protection orders, and we're finding them useful. The thing we found in that data, though, is the biggest way courts were ordering abusers not to contact the victim, not to contact DHS about the victim. The immigration-related power and control continued. The protection orders, the biggest area of violation of protection orders were his efforts to continue to try to get her deported. In the data set we were looking at, and we saw actually abuse rates drop pretty dramatically. Some of that has to do with the fact that many of the perpetrators were also foreign-born. And so they're afraid of the system as well. And so there's some thought, we haven't been able to statistically prove this fully, that compliance rates with protection orders are actually potentially higher among lawful permanent residents and foreign-born people than among citizens. Maybe naturalized citizens included in that because they come from different cultures and they're more afraid of the system. But what we did find is that perpetrators, when you look only at victims who begin the process of filing for immigration relief, VAWA self-petitions, which I'll explain, and U visas, what we find is that the perpetrators continue efforts to get them arrested, so that 26%, or 38% of self-petitioners and 27%, almost 27% of U visa victims, their perpetrators, once they file their immigration case, post-filing, are actively involved in trying to get them deported. They're trying to undermine the access to immigration relief, their involvement with the criminal justice system, their use of the civil justice system. But what we also found is victims who file VAWA self-petitions and U visas, their police reporting rates go sky high. They go way up. Even VAWA self-petitioners who don't have to report. And they start filing protection orders, custody, child support. They start using the court system because they begin to trust people. So what are some of the barriers, from your perspective, what are some of the barriers and fears, in addition to immigration concerns, are you seeing about people, victims, immigrants' willingness to come to court, willingness to call the police for help, willingness to, get involved in a custody case or child abuse case or protection order case. Anybody?
I think it's not uncommon for the petitioner to want safety and want relief, but not necessarily want the respondent deported, and so there's a chilling effect.
Yeah. Others?
Anybody else?
Quiet crowd, listen.
Yeah, what can I say?
Still warm up.
Well, what's interesting about that point is some of the research, the question is why that's happening, right? And what we found is, as we, both in research and in a lot of the cases, but the research says that some of the reason why victims don't want him deported is they believe they have to go with him. If she doesn't know about the VAWA self-petition, doesn't know about a U visa, doesn't know that there are crime victim protections, believe that she has to be deported, believe that her immigration status is connected to his. Many victims believe that when we scratched down the surface and did some research on this, is many of them don't want him to leave because they believe they have to go. The other issue is sometimes, not always, he's really providing economic support to the family that she's dependent on. So that could be one of the other factors that she doesn't want him to go. But again, what we found in doing research among immigrant victims who are pursuing immigration relief is as they learn that they will get legal work authorization, that there is some access to the public benefit safety net, like housing now with VAWA self-petitioners. They're able to begin to envision a life not dependent on him because beginning to pursue immigration relief as soon as possible both brings some protection against deportation and moves them towards legal work authorization and some access to benefits. And benefits in DC are pretty decent compared to other states, and I'll go over what they get. And so, between that, victim advocacy, and support from lawyers, they can often begin to find a way to not be as concerned about his deportation. The other thing that, from a data perspective, we've seen is that when you look at U visa victims who are supposed to be cooperating with the criminal justice system, when we wrote the law, we created an ability to get a U visa certification and get a U visa, even if despite the fact that she didn't cooperate in the criminal case because she was afraid. And so I'm sorry I wrote this, but if her failure to cooperate wasn't unreasonable, these double negatives, then she could still get her U visa. And so we did some research to find out how they were using that exception, and what we actually found was that 98% of the U visa victims ultimately cooperate in the criminal case or are willing to do so, and the criminal case isn't going forward. That doesn't mean they don't go back and forth like any domestic violence or sexual assault victim, but that as they gain more confidence in the system and more stability in the United States and less worry about deportation, they actually begin to participate more in the system. Okay, so there's concerns about retaliation. That retaliation could be in the US, it could be in the home country against family members. They're afraid nothing will happen. Sometimes they'll seek help and the police will show up and they won't speak the language or they won't get an interpreter, and they'll be discouraged about getting help. Or what we found, again, data has found that the perpetrators translate for the police. They're the one that speaks English on the scene. And so you end up getting victims who get arrested as the perpetrator when they're truly the victim. And that's a huge, 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 huge problem. Bigger now in 2017 than it's been in years. And I'll explain that in a little bit. So there's lots of fears and misconceptions. Some women are afraid that if they try to separate from the abuser, he'll get custody, they'll lose their children. He threatens to do that all the time. And then there are also concerns in some communities about retaliation within the community, so that they could be ostracized from their only community, support community in the U.S. So let's start by talking about, so that's kind of some of the background. Any questions about any of the dynamics thus far? Okay, so I'm going to move now to talk about the state of play today, now, in terms of DHS priorities for victim protection and how to best protect victims against immigration enforcement so that they can use the court system and get help from courts. The DHS Victim Witness Memo that was issued in 2012 is still in existence. It is still on the books at DHS. That doesn't control, how would I put this? The ability to enforce it is not the same as it was several months ago. So it is DHS has the discretion to comply with the Victim Witness Memo, but whether or not they'll be forced to do so is an open question. What we do know is that, are any of you either with law enforcement or prosecutor's office or working closely? Well, anyone, law enforcement prosecutors? Okay. Anybody working closely with your law enforcement prosecutors? Okay. So what's important for prosecutors and law enforcement in the room to understand is, what I've been able to confirm is, in the old days, the Victim Witness Memo, it was my job as a lawyer or a victim advocate to work with DHS if my client ended up getting arrested and I had to entangle it. Or if there was a problem with immigration enforcement and my client in the old, in 2016 and before, I could unravel that. Now what I'm being told is the best people to intervene and help are police and prosecutors. So law enforcement talking to law enforcement. So it's important to know and I can give you the contact information of who the liaison people, there are victim witness liaison within DHS, they still exist. There are people within the immigration enforcement realm who are responsible for trying to make sure, because from their perspective, they don't want to get duped by traffickers, domestic violence perpetrators, and sexual assault perpetrators into making the victims disappear. And you guys can be incredibly helpful in helping them not fall into that trap, because the perpetrator is going to be actively trying to get them removed, particularly if there's an open criminal case. And to you victim advocates and attorneys in the room, it's important to develop the relationships and train and work with your law enforcement and prosecutors. So if you're working together on a case, that they can help make that call. And one of the things we can do is provide, if you've got a case, we can help. We can make sure we've got, if you've got a case and you need the name of the exact person to call, we also can call, when it's a case that can't get unraveled at the local level, we can often call people within DHS who can try to intervene. And it's my understanding that our ability to do that continues. So, what I'm going to do is, let's talk a little bit about, I'm going to move now into some more details about immigration relief. There are lots of benefits for survivors about in finding out as early as possible the forms of immigration relief that are available to victims and kids, and getting the case started as soon as possible. The benefits of immigration relief include protection from deportation, enhanced safety for survivors because they're less afraid to come forward, less afraid to seek help. Financial independence from the perpetrator because of work authorization. However, access to work authorization, depending on the form of relief, and I'll explain these a little bit, is 7 months for a VAWA self-petitioner, 28 months for a U visa. So it's a really long processing wait. And so it becomes important when you talk about how long people stay in shelters. I'm going to be talking later on in the afternoon about what benefits and services and government-funded services are available without regarding to immigration status to any victim. Because those services become very, very much more important, particularly for U visa victims during the wait. They get VAWA confidentiality protection, which I'll be talking about in detail. It leads to temporary legal immigration status. Victims can include their undocumented or their immigrant children in their applications. And generally speaking, they get improved outcomes in court and everywhere else, largely because if they're not afraid of deportation anymore, then they're better witnesses. And they're more willing to come forward, and they're less afraid. And so the outcomes are better. And then work authorization in many jurisdictions. I think DC actually has them otherwise. they bring access to a driver's license. In DC, it would be access to a federally issued, a federally recognized ID, even though, because there's driver's licenses in DC without, that are not federally recognized. And that they get some access to public benefits, but the confidentiality protections exist upon filing. So this is a brand new, so I'm going to talk now about give people an overview of the types of immigration relief that are available to help immigrant crime victims. What I'm going to try to do, let's see if I can do the technology piece of this. This is an interactive infographic that was published by the Department of Homeland Security in December of 2016. I'm really excited about this. We all are. We worked really hard with them. And let me show you what this thing does. Now let's see if I can do what the tech guy told me. Okay, so here it is on my screen. So so we're encouraging courts, everybody, police officers, to carry these things around and hand them out. Because if you have the electronic versions, which will be on my website, which you can download, watch what happens. You click on VAWA, and it takes you to the Department of Homeland Security VAWA thing. You click on T-visas, those black circles, it takes you to the application forms. And it does this for all of the various types of victim-centered immigration relief. So the VAWA and explains what they are, very briefly. So it's a great screening tool. And when you think about it, particularly as you get into languages that are not Spanish or English, to some extent, courts can be first responders with an interpreter or with a qualified interpreter. And so courts being one of the places, and your legal aid offices, and the police or prosecutor's offices, or I think your child protective services maybe, or whatever, I'm not sure which one. But the point is, all of those locations, these should be available. This brochure, and then there's another brochure also that explains what a VAWA self-petition is, a U visa and a T visa. And the more information we can get out to people, the sooner. The quicker victims get access to the kind of protection from deportation that begins them on a path towards healing, and a path that really leads them to be more willing and able to effectively use the justice system and seek help. Now let's see if I can get back. Okay. So, and I know you're never supposed to have this kind of detail. They're too small. I'm not expecting you to read them, but I put this up there. This is the word version of that picture that I just showed you. So essentially what I wanted to do is I'm going to briefly explain the reason the two of them are in red. So these are all of the forms of immigration relief that are available to help immigrant crime victim survivors. The one that is less available now than it used to be is prosecutorial discretion. Essentially now, what the state of play is at this time in this administration is once a victim files a VAWA self-petition, a U visa, or a T visa, their case is put in, and I'll show you some slides on this, a special computer system so that immigration enforcement officers can actually see who's a crime victim from their side of the city. But until they file the case, they can't see it. They don't know. And that's the problem. So that the sooner, the sooner somebody can learn about the relief and file it for the case, for the relief, the more protection they get from deportation in this day and age. The two in red are the types of, so that this covers the VAWA self-petition, which I'll explain in more detail in a little bit. VAWA cancellation of removal, which is a protection from, it's a form of relief that you have to have an immigration lawyer, and it's before an immigration judge in a removal or deportation proceeding. There's something called a battered spouse waiver that are, if you're ever working on a case and a client shows you, and I'll give you more details on this later, but a client shows you, or a plaintiff, or a party in court, you see a green card. By the way, they're not always green, but whatever. a lawful permanent residency card that ends 2 years after it's issued. That's a battered spouse waiver case. They're the easiest cases, actually, from an immigration perspective. Then there's gender-based asylum and gender-based asylum. That's usually when the abuse happened abroad. And then the U visa, the T visa, the special immigrant juvenile status, and deferred action for childhood arrival. Yeah.
Why is it that the continued presence does not, it's the only one that doesn't have the ability to apply for permanent status?
Can you all hear?
Yeah, so
Here, can you just repeat that?
yeah.
On the protection for immigrant victims chart here,
Yeah.
it says that, I noticed that all of the considerations, T visa, asylum, U visa, all of that have as one of the benefits ability to apply for permanent status, but the continued presence does not.
Correct.
And I was just wondering why.
So continued presence was developed. So the continued presence is a tool that is available to help victims of human trafficking. The prosecutor or the police officer has to request it from a federal official, and it is a temporary form of status that helps keep people there during the trafficking investigation or prosecution, and it's for potential witnesses in trafficking cases. The avenue to permanent status for those same trafficking victims is the T visa. So people will get, so what's good about continued presence is if a police or prosecutor is involved in the case and they can request continued presence from DHS, that trafficking victim will get immediate access to work authorization and public benefits while the case is going forward and have a stability that, let's say, a U visa crime victim does not. And so that once they start as continued presence, then they can move on to file for a T visa and get the permanent status through the T visa or the U visa.
Okay, thank you.
So, and please feel free to ask questions as they come up. It's not a problem. Yes?
Okay. Just a question on the special immigrant juvenile.
Sure.
I understand, like, if it's for example, in a custody case, a family judge can issue the finding, I guess. But we're getting young girls in our PINS cases where the mother may have come to the United States and established a residency, and the child is coming later from El Salvador, for example, and there's an estrangement. A lot of times, that's how the PIN case dissolves, a family estrangement. But this whole issue of abandonment, is that a decision our judges make?
Yes. So what happens is that, and I'll be talking about this in a little bit more detail when I get to special, but I'll answer the question now, is that in order to issue the findings, it has to be a finding of abuse, abandonment, or neglect. How abuse, abandonment, or neglect is defined is governed by the state law in the jurisdiction of the judge where the order is being issued. So in a question like you're talking about, in the example you're talking about, you would look at DC's either abandonment, abuse, or neglect statutes to see if the facts of that case fit. If they don't fit, then there's no federal definition. You can't use the federal definition, but you can use any definition of abandonment, for example, under DC law. Many states will have abandonment under the child abuse and neglect statutes, but they'll also have abandonment under the UCCJEA. And so you can use either, whatever would be allowable under state law to make that determination.
Thanks.
Yeah, and I definitely will be talking about SIJS and U visas in a bit more detail because they're very relevant to state courts. The one thing I do want to note is that when we talk about the term domestic violence, it's important to understand, and I know this trips up a lot of judges and law clerks and a lot of lawyers for that matter, that the definition of domestic violence under immigration law is broader than any state protection order law in the country. It includes battering or extreme cruelty, and the reason it does is it was founded in the international law concepts of domestic violence and human rights. And so, and also the bipartisan agreements when we were negotiating VAWA was people didn't want to have to wait because the Violence Against Women Act protections helped people married to U.S. citizens and lawful permanent residents, or the children of U.S. citizens or lawful permanent residents. It was decided that by having extreme cruelty as an option, and they literally turned, the definition is the old for-cause family law definition of protection of extreme cruelty. And that it allows people to get help and get out without requiring the first meeting. It allows people to get help without waiting for the abuse to escalate. And that the immigrant protection covers a whole range of victims. It covers adult, child, and elder abuse victims of domestic violence, sexual assault, human trafficking, dating violence as defined under the state law, DC statute, stalking, and many violent crimes, and I'll go over that list. And that it also covers child victims, as I said earlier, of abuse, abandonment, and neglect. Immigrant children before the courts have a range of options. Some of them are based on their own victimization. If a child has been abused, abandonment, neglect, they may have their own direct right to a legal immigration status based on their own application. And in some of those applications, U visas and VAWAs being an example, they can include their non-abused parents that are undocumented in the application as well. So the idea is protecting mom or dad helps protect, helping protect the non-abused parent, helps the non-abusive parent, helps protect the child. And so children can be included in their abused mom's application, whether or not they're abused. And if the children are abused, they can have their own application and potentially include their non-abusive parent. And then I talked about the brochures. So one of the other things I want to talk about is kind of the role of courts, court systems, and victims and victim advocates in helping victims and kids access the immigration relief they're eligible for. As I said, courts can be the first responder. I really encourage courts, all of you, to think about, and I was really excited within 3 weeks after the infographic came out, somebody sent me a text picture of a courtroom in San Antonio, Texas, where the judge on the bench behind them had a bulletin board with the infographic behind. So I was so excited. But courts can, distributing information, the DHS, I'm not asking you to give legal advice or anything like that, it's just distribute the DHS produced information can be really, really helpful at courthouses, in courtrooms, in all of our projects. Providing language access is significantly important, and then recognizing who's eligible for what can be very helpful as a judge sitting in a case, because there are things courts can do to encourage counsel. You may suspect that somebody's a trafficking victim, or you may suspect that somebody's eligible for something and counsel doesn't raise it. And so there are ways courts can give counsel time to look into things. I mean, there are things you could do to trigger getting information to that person about legal relief that might be available. There's also all kinds, it's important for courts to know what people are eligible for in terms of services and benefits, so that you're not ordering a family to access a public benefit they're not legally eligible to receive. And so we'll be talking about that. And then it's really important, we'll be talking about this in the custody section a little bit. We did research, we looked at all of the reported family court cases that mentioned the word immigrant or immigration. And we were able to see a pattern nationally of ways in which, where courts had legally inaccurate information. Because if you think about it, one party testifies, the other party testifies, and the court based on that decides what immigration law really is. It doesn't work. And it's hard so that's why we've developed a library of resources with SGI funds for courts. And we have, I promised the judge I'd mention this, we provide, the pens we handed out have a phone number on them. And if you're a judge or a clerk and you want to get connected with a judge that provides technical assistance nationally to other judges on this, we can make that connection for you. You can call us and we'll have one of our judges call you back. One of the judges that's been doing the national trainings with us. So we try to do that. We also can provide you direct TA, but a lot of judges are more comfortable talking to other judges, so we can try to make that happen. We have 7 nationally right now. I just got a grant, and that team of judges will be growing to about 30 over the next year. From attorneys and advocates and caseworkers, it's important to know the forms of immigration relief. to document the history of abuse and to help victims file as soon as possible. Because as a bottom line right now, until the case is filed, there is no protection from deportation. It's very hard to make it work other than through your police and prosecutors when there's no case filed. And that safety planning is really important. So I'm going to talk a little bit more about VAWA confidentiality and give you, VAWA confidentiality is important for it does like 3 things. It precludes the Department of Homeland Security from relying on perpetrator-provided information, except under limited circumstances. It has locational protections. So related to that, let's put it this way, DHS, the Department of Homeland Security, isn't going to randomly show up in a contested custody proceeding courtroom. And they're not going to randomly show up in a protection order courtroom. Usually it's related on, they end up there because of a tip from the abuser. And if in fact, so the federal law says that if the DHS is precluded from courthouse enforcement related to cases of immigrant crime victims, and if they do any kind of courthouse enforcement or anything within or near a courthouse, they have to prove in the filings before the immigration judge in any case brought that they didn't rely on perpetrator-provided information. So I'm going to explain a little bit more about how that works. And then there are non-disclosure provisions when somebody files a case that is important because, that we'll talk about in a little bit more detail, because perpetrators of domestic violence, sexual assault, and human trafficking in family court cases and criminal court cases, but we see it more in family, although you'd expect to see it more in criminal, are trying to convince state court judges to release information that's federally protected from release. And so we have case law and information about what the rules and the laws are on that. So the non-disclosure provisions apply to anybody who's filed a VAWA self-petition, a U visa, or a T visa case. Again, it doesn't apply to continued presence. There's a question about whether it could, but we're not likely to get any traction on that at this moment. So it's VAWA T and U visa cases. It doesn't apply to special immigrant juvenile status cases, and it doesn't apply to asylum cases. They have their own confidentiality that's not as strong. The prohibitions on perpetrator-provided information applies to any family members who are abusers or crime perpetrators, so it applies to any domestic violence case, whether or not it's filed, the immigration case is filed. But in terms of a victim where let's say the abuser is a spouse or parent, or let's say an LGBT case, or parties who are girlfriend, boyfriend, the protections against perpetrator-provided information only kick in once the case is filed or DHS knows that person is a perpetrator. So it's a little bit different there. And then the locational provisions apply to everybody. You don't have to have the immigration case filed first. The problem is, again, in this day and age, having the immigration case filed gives you a better way to enforce, to keep DHS from doing immigration enforcement at the courthouse or in a protection order or at a rape crisis center or other places. Yes?
I have two questions.
Hold on one second.
So one of my questions is about the location prohibitions that you were talking about. And I have a question about how that's read sort of at the courthouse, whether that means in the court part, whether that means standing on the sidewalk outside of the courthouse, sort of how geographically broad is that? As a hospital, any sort of medical center? Is it actually just a hospital? That sort of thing.
Okay.
And the other question is about talking about the abuser provided information. If information is provided subsequently to DHS as to the abusive nature of a relationship, can the protections be invoked retroactively?
Okay, let me start with the second one first, just so I remember it, and you might need to, Judge, maybe you can stay here.
I'm staying in her location.
Okay. As to retroactively, so the way I like to think about it is that, yes, once somebody files a case, they can try to unravel what's happened before. The problem is DHS is a law enforcement agency. And as with many law enforcement agencies, if they're already doing an enforcement action and they say, oh, by the way, I was abused, they're more suspicious. It's harder to undo it. And that's the problem. That's why one of the things is we're telling people to file as soon as possible, but to file solid cases. So filing, flimsy cases where you're not going to be able to prove up the evidence is dangerous too now. So you want to, if you have a legitimate case, you want to get that U visa certification, for example, in a U visa case, and you want to file it as soon as possible, because if the enforcement happens after it's on file, they're more willing to credit the legitimacy of the abuse than if it happens in reaction. And what you have to understand is, think about it this way, and if you're sitting at the DHS end, because this really does happen, and imagine every person who's foreign-born, who's an immigrant, who's convicted of a crime, who's tried every other way in the world to get legal immigration status, and at the end they say, oh, by the way, I'm an immigrant, I'm a victim, and they try and file something. This happens all the time, and DHS gets flooded with those. So what happens is if the, sorry, I have surgery on my foot, and so sometimes it hurts to stand. I'm trying to balance here. When you discover it later and are going to DHS after they've already got involved in an enforcement action against her, it's just harder advocacy. It's not that you can't win, but you're going to need stronger evidence of abuse and all of that other kind of stuff. Okay, now, now I'm trying to remember the question before. This is where being 60 is like, okay, what was it that you?
How big is the
location? Yeah. So as to again, historically, because that's all we know right now. So in Delaware, there was a case where the interpreters were available for protection orders every Wednesday afternoon. And every Wednesday afternoon, in the parking lot across the street from the courthouse, ICE would show up. Those ICE officers got, it's not really prosecuted, investigated, and there were sanctions. That's what I know. So it has included areas around courthouses. I don't know if it will continue to going forward, but it could. It certainly includes inside the courthouse, because the issue here is the statutes on the books that provide some limitation on courthouse enforcement around immigration are only VAWA related, okay? And so they're only related to the Violence Against Women Act, which means the case has to involve a victim of domestic violence, sexual assault, human trafficking, or a U visa criminal activity. But then when it involves that victim, it could be the traffic ticket case, it could be a protection order case, it could be a landlord-tenant case, it could be a criminal case. It's not about the case, it's about the victim. But generally speaking, 90% of what we see are protection order courts and custody is where where we see the issues coming up. Okay. So the forms of immigration relief that receive VAWA confidentiality protection upon filing include the VAWA self-petition, the VAWA cases before immigration judges called cancellation and removal and suspension of deportation, the battered spouse waiver case, U visas, T visas, and there's a brand new form of immigration relief, and I'm happy to announce that the form for it came out February 14th, 2017. Okay? And so it's a form of relief we wrote as part of the Violence Against Women Act of 2005, but in DC it's super, super, super important. Because what this is that if you have a family on a diplomatic visa, a work visa, like a tech work industry visa, somebody who's working for an embassy or international organization, those people, they can bring their family members, and their family members can't work. But if they're abused, they can now file for work authorization, and it's brand new. It was just implemented by the Trump administration I think it's particularly appropriate, that was February 14th. So that's a new form of visa, and those victims also get VAWA confidentiality protection. That's another example of a victim that has no path to lawful permanent residency or naturalization through their current visa, but that's a group of victims who can get work authorization now and then go file for a U visa. So they have work authorization during that 28-month processing time. And you'll see these cases probably more in DC than DC and New York are going to probably be the places where you'll see them most. Okay, and then they're barred from relying on perpetrator-provided information by the trafficker, the crime victim, etc. And that the statutes or the policies in place within Immigration and Customs Enforcement say that they have to comply with VAWA confidentiality protections the moment they have reasonable belief based on credible evidence that the person is a VAWA T or U visa victim. Okay, that's what the law is. There is a red flag system I told you about within DHS that flags these cases to try to prevent immigration enforcement against victims and prevent officers from being duped by perpetrators, essentially. The locational prohibitions we talked about apply to not only courts, but they apply to rape crisis centers, shelters, supervised visitation centers, family justice centers, victim services programs, NGOs in the community, and courthouses. They don't apply, they don't apply to hospitals. There isn't a hospital protection, okay? And that now turning lastly to the prohibition on disclosure of information. So once somebody files a VAWA T or U visa case, and this becomes relevant because I said as family court and criminal court discovery are big issues, big areas. And what the federal law says is that once you file a VAWA T or U visa case, the information protected is the file. They're protected against disclosure of information about even the existence of the case or action taken in the case. So none of those will be released by the Department of Homeland Security, and they're all protected by VAWA confidentiality. And the primary person that they're trying to protect against disclosure is the perpetrator, but the federal law covers it essentially to any person, even within DHS. So that red flag system I was telling you about, it says it's a red flag case, but it doesn't say whether it's a trafficking victim or rape victim or a child abuse victim or elder abuse or domestic violence. It just says flagged, hands off, essentially. And that the VAWA confidentiality protection applies from the moment the case is filed until it's denied on its merits and appeal has run. If it is never denied, it applies forever. So after naturalization, 10, 15 years from now, it is sealed. They can't get it. And I'll go over the case law around this in a minute. These are all the different kinds of cases. There's a list of cases that it applies to. Again, VAWA self-petition for this definition and for public benefits definition is quite broad. It includes battered spouse waivers, VAWA self-petitioners, and then there's Cuban, Haitians, and Nicaraguans, Central American Relief Act. There's these smaller categories of people. And these groups of work authorization spouses for the purposes of the, they don't get housing, they get the other stuff. Okay. There are narrow disclosure exceptions, and judges, this will be something you'll have people arguing about. So the truth of the matter is that the disclosure, there's like an exception for, there's a judicial exception. That has been interpreted by DHS and by federal courts to be the appeals of the the victim's immigration case. It is not every judge in any state court, because you've never had that normally before you. So the exception for, judicial exception is related to immigration cases, and there's public benefits granting purposes exceptions and congressional oversight and things like that. It's very narrow. Law enforcement for a legitimate law enforcement purpose. So, prosecutor, I assume that's, I think. So from a prosecutor perspective, the U visa cert itself is discoverable in criminal case. but nothing else. Why? Because the cert is part of your records. It's something that a police officer, a prosecutor, or a judge, or a CPS or APS did. But that's all that's discoverable, not the whether or not she ever. We've had cases where they tried to figure out, they tried to discover, because you could do a cert and they could never file the case. You don't control the filing, you only control the cert. So it's only as to the cert itself, and that's what can come into a criminal case. Could be the same thing in a family court case as well. I'll give you the case law on that in a second. Each violation of VAWA confidentiality for via DHS or Department of State, Department of Justice, State Department official is potentially a $5,000 fine per incident and demotion, and there have been demotions. I don't know if there have been fines. They're not so transparent about all that part. And can result in the dismissal of the immigration case brought against the victim. You know, it's a little bit of a fruit of a poisonous tree kind of argument. And that, okay, we kind of talked about this. So the federal case law involves confidentiality. There are kind of three kinds of cases. There's actually 4 cases, but the criminal case I've been able to get my hands on is actually under seal. I haven't actually seen it. I know who has it. So you're a federal prosecutor, right?
Local.
Local, okay. It's possible, I know that like DHS, Office of Violence Against Women has the case, and they will release it to another federal official. And I don't know if DC counts, you know, and that they might. But the point is that in the criminal case, there were 2 or 3 criminal cases where the federal district courts in the criminal cases have ruled that they're not releasing the file. But then 2 of them are sealed because of the confidentiality. That's the problem. But there are 3 reported federal district court cases in VAWA, in which they've said that VAWA confidentiality protects against, unless it's based on its merits, and that the exception of judicial review, as I said in the Haw case, applies only to immigration courts. The Sixth Amendment right to compulsory process does not permit access to absolutely privileged information, and that the primary purposes of VAWA confidentiality is to prohibit the information from getting to the accused perpetrator, the accused batterer. So when you're talking about state court cases, criminal or civil, there's no way to really release the information in a domestic violence or sexual assault trafficking case when the opposing party is the trafficker or the perpetrator without releasing it to the very person that the statute was designed to protect. So it has been ruled not discoverable. They've also found that although relevant to credibility and impeachment, discovery was barred as contrary to purposes of VAWA confidentiality in the federal statute. This is a U-Visa case that was started as a family court case, and that essentially what they ruled that the perpetrator was trying to do was interfere with the victim's immigration case, which is one of the purposes, and also to discover information about her location and things like that that might be contained in the immigration file. And that, okay, so it's barred. Then the most recent case is an EEOC versus Koch case. And in that case, that was an employment case, and I don't know to what extent you're seeing employment discrimination cases. I'm sure you are here in DC court, but it might be more federal. But the point is, in that case, what they did was allowed limited discovery of the U-Visa certs in the end at the liability phase of the employment case. And I raise this, judges, because opposing parties are going to raise this to you. And what's important to understand is that was a case in which you could actually do there were like 50 victims. And so they released the certs, but they didn't, they took out who they belonged to. So they didn't know which victimization happened to which person. And they could protect the confidentiality of the individual victim in that employment case because it was such a big class of people. You can't do that in a protection order case because you're releasing it to the perpetrator. And there, in the EEOC case, the defendant was the boss of the sexual assault perpetrator, not the sexual assault perpetrator themselves. So it's just important to know that while this might appear to be mixed case law, the Fifth Circuit, which is the highest court that's ever seen this, was very clear that discovery, if it's done, it has to be in a way that doesn't undermine or jeopardize the bubble confidentiality laws and what they're designed to do. So that gets me to the end of kind of the enforcement issues and where they are today. Any questions about that further? And where I'm moving next is I'm going to be talking about special immigrant juvenile status. We're good? And if you think of them later, don't hesitate to raise your hand. So, okay. So now there are two areas of the law where Congress created an explicit role for state court judges. And that generally speaking, making detailed findings in any case, particularly when you've got a party before you who's an immigrant, if you're making detailed findings of child abuse or abandonment or neglect or domestic violence or sexual assault or human trafficking, those findings can be incredibly helpful to any crime victim's immigration case. Okay? They're not required in a self-petitioning case or not required in a trafficking case, but they're helpful. And that having those kinds of detailed findings and being able to initiate immigration relief puts people on a path to lawful status. Okay. And that courts, one of the things that the National Center for State Courts did a very interesting report in 2006. It was National Institute of Justice funded. And the report looked at what courts were doing the best job with language access. And one of the things that they found, and we've done other research to see that it's true in other contexts, is that where the courts had events like this and relationships with the NGOs that were serving immigrant populations, they did a better job with language access, they did a better job with visa certification. Same thing with police, same thing with prosecutors. That those relationships matter, and they're important in terms of access to justice. So, U visas. So I'm going to start with the U visa. So what is a U visa? Who qualifies? It's an immigrant victim of a qualifying criminal activity, and I'll show you the list. When we wrote the statute, we chose qualifying criminal activity or criminal activity as opposed to crime because Congress intentionally wanted people to be able to get immigration relief as early as possible in the process. The idea was, a law enforcement officer, who was the chief of the Appleton, Wisconsin Police Department, who was one of my law enforcement trainers for years, he testified before Congress on this, and he says, to me, it is not 10,000 U visas a year. It's 10,000 tips. It's 10,000 people coming to us with information that we wouldn't otherwise have. And that's part of what the U visa was designed to do. So it has to be a qualifying criminal activity. It has to have occurred in the U.S. or violated U.S. law. The victim has to possess information about the crime. And they have to have been helpful. They have to be currently being helpful, have been helpful in the past, or likely to be helpful in the detection, investigation, prosecution, conviction, or sentencing. And those are all ors of the offense. Okay? So what's important there is, courts don't prosecute and investigate, right? Judges, they don't do that. But you sentence and convict. But courts also detect. Courts also detect criminal activities when somebody comes in and files for